Good afternoon, everyone, and thank you for joining us for today's webinar entitled Key Personnel Requirements Related to Government Solicitations. I'm Kim Nucci, and I'm presenting to you from Thompson Coburn's Washington, D.C. office, and I'm joined by my colleague Scott Lane, who's presenting from our St. Louis office. Before we begin with the presentation, I want to cover a few housekeeping items. If you have any questions during this webcast, you can submit them through the Q&A widget. I've asked why it's called a widget. I don't know why, but it's like an icon, but it's at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. A copy of today's slide deck is available on the resource widget. We encourage you to download it for future reference. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. If your screen freezes or if you encounter other technical issues, just press F5 on your keyboard and it will refresh the screen and fix most problems. If you continue to have problems, though, please send us a note using the Q&A widget and our staff will assist you. This webinar is CLA accredited in California and Illinois for 1 hour general CLE credit, and in Missouri for 1.2 hours of general CLE credit. We award CLE based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. We really appreciate your participation in this course, which will begin now. Starting with the most basic of our presentation is what are key personnel requirements in government solicitations. Primarily in service solicitations, you will often find instructions requiring offerors to propose specific personnel who are designated as key for purposes of contract performance. And you'll also usually find evaluation criteria that dictate that the proposed key personnel must meet or exceed the specified requirements in order to be eligible for award. Satisfying key personnel requirements is considered a material aspect of an offeror's compliance with the solicitation and the offeror's ability to perform the resulting contract. So what are the typical key personnel requirements? They generally include a description of the minimum experience, education, and qualifications that must be met by the individuals to fill the specified positions. You usually will find these descriptions in the statement of work or the performance work statement as part of the solicitation. The requirement is often that you must submit the names and resumes of proposed key personnel so that the agencies can review them and verify that the persons you are proposing meet the minimum requirements. In addition, you may be required to provide signed letters of intent or a commitment from the proposed key personnel. This is particularly true for contingent hires. The types of things that you'll often see in terms of the requirements are, in terms of experience, it may be they have to have a total number of years working in this type of industry or position. Education, they sometimes dictate that you have to have a BA in a certain area of study, such as computer science. Some even require a master's degree. You'll often see certification requirements, such as project management professional certification, or PMP. These are the typical kinds of things that you will see in the solicitation in terms of the minimum requirements for key personnel. So what happens if you don't strictly comply? Well, your proposal likely will be deemed ineligible for the resulting contract award, which obviously you do want to avoid. So we've come up with this minimum contractors checklist. The first thing is you must ensure that the key personnel that you're going to propose meet or exceed the minimum education, experience, and qualification requirements specified in the solicitation. I know that sounds very obvious to you, but you would be very surprised to learn how many times offerors submit key personnel submissions or resumes that don't demonstrate that they meet all of these requirements. And I can tell you that as bid protest attorneys, that's one thing that we will first scour in a protest is an offerors or the awardees' key personnel submissions and their resumes. And you'd be surprised how many problems we find with those. The resumes then should be current, accurate, and they show that they are fully qualified. The people that you're proposing are fully qualified. For example, make sure that the title that you are giving to this person that you're proposing is consistent with the title in the RFP. Make sure for education that you show the degrees and preferably where they're from and the dates of those degrees. And then for the employment dates, when you're listing in the resume the various employers and types of work that you've done for those employers, make sure that you show the years that that person worked at that employer, because you want to make sure all the years add up to show that the minimum experience requirement is met. Again, you'd be surprised how many resumes we have looked at in the context of bid protests where the experience shown on the resume doesn't add up to what the solicitation requires. You also need to check to see if the solicitation requires you to submit commitment letters. If it does, follow those instructions to the letter. Make sure that the content of those commitment letters is consistent with what the solicitation says. And sometimes they'll even tell you exactly the language and the phrasing to use in the commitment letters. And get the candidate's signatures. And we often find that the commitment letters also have to be signed by the employer. Make sure you get those signatures. If the solicitation doesn't require you to submit a commitment letter, we think it's a very good idea that you ask the proposed person to give you a commitment letter that you keep in the file. And that will show that this person is committed to going to work for you if you win the award of the contract and will be available. So we have these few warnings, which, again, may seem to state the obvious, but it's very important to heed these warnings. Do not propose individuals that you know or have reason to know may not be available to work on the contract. And do not use resumes without the knowledge and consent of the candidates. You'll hear when we talk about some case studies later on that offerors frequently do that, amazingly enough. You will also find that there are always delays in procurements. I mean, almost always there's a delay. And this can wreak havoc on a contractor's continuing compliance with the key personnel requirements, because it increases the possibility that proposed key personnel are no longer available because of job changes, layoffs, illness, even death, and for any other types of reasons. It just happens when months and months go by after you submit your initial proposal. And this obviously is especially true with respect to contingent hires who are, not working for you and are sort of outside your control to find out what's going on with them.
That's right, Kim. This is Scott Lane. I'm a partner in Thompson Coburn's government contracting group as well. I've been working in government contracting field for about 15 years, first 5 at Boeing, and then about 10 years here at Thompson Coburn. And I would echo Kim's sentiment that these are the types of things that in doing a bid protest, whenever we see an awardee's proposal, one of the first things that we're going to be checking for is whether their resumes have, dotted the I's and crossed the T's, if you will, to see if there's any non-compliances that could be found. On the other side of that, of course, we often see situations where maybe our client is kicked out of a competition because their resumes weren't compliant in some respect. But at the end of the day, preparing like that, making sure that you've complied with the solicitation requirements only carries you so far. as Kim indicated, life happens. And sometimes, even where you've followed all the right procedures to ensure that you have an initial proposal that meets all of those requirements, sometimes the person isn't available after months might go by without a contract award. And so a big part of our presentation today is covering what is it you're supposed to do in that situation. Of course, you have to quickly find a qualified substitute. But what about your proposal? And the answer very much depends on the status of the solicitation itself. If you're before proposals have went in, of course, you make sure that when you submit it, you've got everything accurate. But if it's after the proposal has went in and before a contract has been awarded, whenever you're at risk. So let's consider that situation. Proposals have been submitted, no award's been announced. And if the agency has planned to make this contract award without engaging in discussions, which are what some of you might know as evaluation notices or exchanges in an RFP that allow you to revise your proposal, you're in a very, very difficult situation because the bid protest decisions state that offerors are obligated to advise the government when their proposed key person becomes unavailable after proposals go in. If you don't advise the government that this person has become unavailable, then you risk being found to have misrepresented your capabilities. And the other side of that, of course, is that the bid protest decisions state that whenever there's a requirement for resumes of key personnel, those resumes are a material requirement. And the critical point here is that when the agency is notified that your person has withdrawn, it only has two options. Either evaluate the proposal as submitted, where it's going to be rejected as technically unacceptable for failing to meet that material requirement, or open discussions to permit that offeror and other offerors to revise their proposals. Now, when you provide that notification to the agency that your key person is no longer available, you certainly would want to propose a substitute along with that person's resume and even a commitment letter, going back and looking at the RFP to make sure that you've met all of the pertinent requirements there. But if the agency hasn't opened discussions, the agency isn't going to accept that resume, that substitute person, because it would effectively be a late proposal.
And I would just add real quickly to that, Scott, this rule that Scott mentioned, where the GAO decisions say that once the agency gets notice that a key person is withdrawn. I know I was asked by someone who took a look at this, and they said, well, wait a minute. Well, what if your key person dies after you submit your initial proposal? Shouldn't the agency just be looking at the initial proposal and its acceptability as of the submission date? And the answer to that is no, even though that would seem to be fair and logical. The answer is the agency then will evaluate the proposal with the knowledge that your key person is no longer there, no longer available, and it's a problem.
Right, and so you're in the situation of where you've essentially got to ask the agency to open discussions to allow you to revise your proposal and substitute that key person. Of course, the agency could decide to do that on its own as well. But the difficulty there is that agencies are not obligated to open discussions in those situations. And there have been cases like the situation that Kim's mentioned here, where a key person becomes ill and unable to serve in the same capacity after proposals have went in, and the agency is not obligated to open discussions for that to happen. This is particularly true where, as we often see in RFPs, the agency reserves the right to make an award without holding discussions. Now, if an agency declines then to open discussions, and you've notified the agency of the unavailability of one of your key person, you're running the risk, of course, that your proposal is going to be evaluated as unacceptable. And, we want to point out that, your reactions to this are probably that that's extremely unfair. And we agree, particularly where that unavailability has occurred through no fault of the offeror, and could be, as Kim's indicated, the consequence of delays in the procurement on the agency side or bid protests. And ultimately, from a contractor's perspective, these things ought to be resolved fairly quickly with a limited proposal revision. But again, contracting agencies have their own interests in mind on their procurement approach, whether that's timing of the award for performance or funding reasons, or avoiding protestable issues, or whatever other causes that you can infer that they might have of trying to exclude one offeror over another. There's a lot of reasons why an agency will decline to open discussions in these types of situations. Now, all of this probably leads you with the conclusion of maybe if I have this type of issue, I should just stay silent, with the hopes of substituting the key person after the contract has been awarded. But you have to beware here. As the heading on this slide shows, silence not necessarily golden. This comes out of the fact that most contracts and solicitations will require you to substitute your key personnel during contract performance. And the case law shows that whether personnel identified in the proposal end up actually performing the work is generally considered a matter of contract administration, which means in the bid protest world that it's not typically a protestable issue. But that substitution may not be completely immune. In particular, there are two categories of protest grounds that the GAO or the U.S. Court of Federal Claims have considered regarding approaches where offerors stay silent on a change in their key personnel. And the first of those is referred to as a misrepresentation, a material misrepresentation of the proposal. And the second category of cases here involves what's referred to as a bait and switch. And there's slight nuances in the differences of the tests used at GAO versus the court. Generally, establishing a bait and switch at the GAO requires satisfying a more stringent test than misrepresentation. At the court, however, a recent case that we'll be talking about applied a very low bar to showing even a bait and switch in a recent case. And ultimately, establishing either one of these different causes can result in the loss of your contract if you stayed silent during the proposal period.
Yeah, and we're going to discuss, I'm going to discuss a couple of recent cases on this, and we've gotten a question from one of the attendees that I think my discussion of these cases will answer about. The question is, what's the threshold for deeming a person as unavailable? Does a person have to have a written withdrawal of the candidate or just a reasonable belief? I think as I discuss these cases, you'll see what the GAO considers and the court considers in answering that question. The first case, it's a GAO decision that was just issued in 2018 called Sev 1 Tech. I'm just going to briefly describe the facts in this case, but it involved a misrepresentation regarding the key personnel proposed by the awardee, which is STI Tech, in its proposal. And STI Tech used incumbent staff resumes. Now, it got those resumes from its proposed subcontractor, who apparently had access to resumes in a database of people who had worked on prior task orders for this agency and this type of work. So the subcontractor handed over these incumbent staff resumes to this offeror, STI Tech, and its proposal actually said that it had reached out to and negotiated contingent offers of employment with the candidates whose resumes were used. It turned out, though, that was certainly not the case. that they didn't even contact the people that they proposed until after they got notice of award, and they certainly had no commitments or expressions of willingness by the individuals to consider employment with STI Tech. Well, guess what? The incumbent SEV1 Tech protested. And, of course, they were in the better position to know whether its employees had actually been in touch with STI Tech or given them their resumes. And, of course, they had not. Turns out, because the agency didn't know any of this, STI Tech received the highest rating for its staffing approach on the basis of these great resumes. And so then we got a protest from the incumbent at SEV1 Tech, and GAO sustained the protest, ruling that STI Tech had materially misrepresented the personnel that it was proposing, and that had a material influence on the agency's evaluation. According to the GAO, while an offeror can submit the resumes for another company's employees, and certainly that happens all the time, it's not a misrepresentation where prior to submission, the employees expressed a willingness to become employed by the awardee. On the other hand, an offeror, and I'm quoting here, may not represent the commitment of incumbent employees based only on a hope or a belief that the offeror will ultimately be able to make good on its representation. Now, of course, as you probably know, if you're involved in competitive procurements, offerors often expect incumbent employees to want to go to work for the new awardee if it has to change hands, if the contract changes hands. And so they reasonably believe probably that they can reach out to the incumbent people and hire them, interview them and hire them, because the incumbent people want their job. But you have to reach out to them beforehand if you can, and you cannot use their resumes without their consent and without understanding that they're willing to consider working for you. So the result, the outcome here at GAO in this case, was that GAO didn't recommend that this company be eliminated from the competition, but instead recommended that the agency reevaluate STI Tech's proposal with the knowledge that it made these misrepresentations in its resumes. Now, we don't know how that case turned out, but I suspect that in the new source selection decision, STI Tech was not selected as the awardee. What GAO said in that case, in terms of deciding the appropriate remedy, when you have what happened here was a material misrepresentation in the proposal, is GAO typically considers the degree of negligence or intentionality of the offeror's misrepresentation, as well as the significance of that misrepresentation on the ultimate evaluation. I'm going to talk about another GAO decision here, which was issued in 2016, because it's similar to, but contrasts somewhat to the SEV1 Tech decision. In Patricio Enterprises, the evidence established that the awardee had knowingly or negligently represented in its proposal that it would provide the named key personnel of the incumbent, who was Patricio. The awardee's proposal actually stated that it had signed contingent employment offers when, in fact, it had no such letters and had not even discussed employment with the most of the proposed personnel. And it turned out that the awardee, whose name was Knowledge Capital Associates, or KCA, received the highest rating for the management staffing proposal based on the key personnel that it proposed. So what happened in this case? GAO, of course, sustained the protest, and it concluded that based on the evidence, the awardee's proposal misrepresented the commitment of the non-KCA employees to work for the awardee, which in turn misrepresented the ability of the awardee to provide those individuals at the start of performance. So what was the remedy in this case? Unlike the case in SEV1 Tech, GAO here recommended that the agency exclude the initial awardee's proposal from the competition on the basis that the integrity of the procurement system demands no less than the remedy of exclusion. So you wonder, well, why the harsher result in this case than the result in the Sev 1 Tech case? And I can't really answer the question definitively, but I can tell you that the proposal clearly reflected an intent to mislead the agency. It said it had contacted the employees and it had letters of commitment. And when the GAO attorney responsible for the protest asked the counsel for KCA to explain that, how could they say that in their proposal? I have to tell you, they gave some pretty lame excuses. We prepared the letters in advance, but we forgot to give them to the employees before we submitted our proposal. That just didn't fly with the GAO. And the evidence clearly showed that they had no reasonable basis to represent that the personnel that they were proposing would be available for contract performance. So what are the lessons learned from these two cases? I mean, these cases are unusual because, I'm sure you're all thinking, I would never say that in my proposal if I hadn't actually talked to the people and gotten their commitment or at least an expression of willingness to come to work for me if I won the award. But it happens. I mean, we've seen a lot of cases like this. It wouldn't happen, though, in a situation where the offerors initially proposed key personnel, were aware of, and agreed to the offeror's use of their resumes, but they subsequently became unavailable before award was made. You can see there's some very there's a lot of nuances that come into play here in determining whether a representation is a misrepresentation or just a situation where they represented accurately, but then events changed that representation later on. A material misrepresentation could be found if the offeror is afforded the opportunity to submit a revised proposal as a result of discussions, and then doesn't take that opportunity to submit a substitute for a key person who the offeror knows is no longer available. Now I'm going to turn it over to Scott to discuss more about the bait and switch.
Right, so turning to the second general category of protest grounds on this type of issue, the bait and switch. Both the GAO and the Court of Federal Claims have similar standards to be met in order to prove this allegation. According to the GAO, to establish an impermissible bait and switch, protester has to show, as you see here on the slide, knowingly or negligent representation that it would rely on specific personnel, that it didn't have a reasonable basis to expect. The misrepresentation was relied on by the agency, and the agency's reliance had a material effect on the evaluation results. These are effectively the misrepresentation side of a bait and switch. But in order to succeed in proving a bait and switch, there's oftentimes considered another aspect of this as well, referred to as the baiting element. And what this goes to is GAO will find that even where there's evidence of a planned switch in personnel, they will not find an impermissible bait and switch if there's no evidence of baiting. That is, replacing proposed key personnel with less qualified personnel. Essentially, this is because the substitution of equally or better qualified personnel couldn't have had a material effect on the evaluation and doesn't result in any prejudice to the government or other parties. In comparison, the Court of Federal Claims has also decided bait and switch allegations, and the standard there requires the protester to show that the awardee representative would rely on certain specified personnel. The agency relied on that representation. It was foreseeable that the individuals named in the proposal would not be available, and personnel other than those proposed are performing the services. There's several nuanced differences in the test at the GAO versus the court. that you'll see here. At the GAO, again, the standard is knowingly or negligently represented these personnel would be available and didn't have a reasonable basis to expect performance. At the court, it's really focusing, that three of these four elements are fairly easily established, and it comes down to this foreseeability element. And foreseeability, this element the court has held, the appropriate standard is whether you negligently or knowingly proposed individuals that would not be available to perform the contract. Again, it's comparable to GAO standards, but in application, there's been differences in these. And the fourth element, the final element of the bait and switch test, the Fulcra Court, which was a decision that's often been cited at the Court of Federal Claims involving bait and switch allegations, the court held that a bait and switch can't be proven where contract performance has not yet begun. And so that essentially goes to the fact that the protester has to prove that the personnel other than proposed are performing the services. Instead, the court found the plaintiff has to demonstrate that personnel other than those proposed are or will be performing. And so the summary here is that many of these misrepresentation and bait and switch allegations are essentially losing incumbents who learned that the awardee was recruiting their employees, or disappointed offerors who see job postings by the awardee for the same positions that were supposed to be filled by key personnel. And the GAO and the court make it clear that there's nothing improper about an awardee seeking to hire incumbent personnel or posting job openings. In addition, where there's no evidence that the offeror proposed personnel it didn't expect to actually use, the number of substitutions of key personnel by itself doesn't provide a basis to sustain a bait and switch. With that, I'll turn it back over to Kim.
As this slide indicates, we haven't found any court cases that apply that same baiting element that GAO applies. Which the baiting element is interesting because you can understand why they have this requirement, because if you propose highly qualified key personnel that I like to akin to proposing the Cadillac of people. If you suddenly change them for purposes of contract performance with lesser qualified people and probably people who cost you a lot less, the agency isn't getting the benefit of the bargain it thought it was making, and the contractor is probably going to have a windfall in terms of additional profits because it's paying for lesser qualified people. But again, that's a requirement that's imposed by GAO. We have not seen any cases at the court that imposes the abating element. And as Scott pointed out, both GAO and the Court of Federal Claims have made it clear that there's nothing wrong with an awardee seeking to hire the incumbent people. It happens all the time. In fact, as many of you may know, in the service contracting area, there's an executive order NFR clause that actually requires awardees to give incumbent personnel a right of first refusal to become employed by them. Now, that just applies to non-management personnel, and I'd say that probably most key personnel positions are also exempt managerial positions, but that's not always the case. But like Scott said, we get questions all the time from losing incumbents who say, wait a minute, I see all these job posting out there to hire all the people, all the key personnel that they were required to propose. So they're switching. they're baiting and switching, and we have to explain that that's not necessarily improper, that it's actually quite typical to be going out there, an awardee to be going out there and actively recruiting the incumbent people. Because, as maybe some of you have encountered, incumbents don't want others to come in and start talking to their people. They don't want their people to give them resumes. They want to have that upper hand, that advantage in the procurement. And sometimes I've heard that some companies absolutely prohibit their employees from talking to competitors and giving them their resumes. So it's difficult out there. Now, where the continued availability of proposed key personnel is not known, this is the ignorance can be bliss. And this is particularly true with contingent hires, people who aren't working for you and that you don't see on a day-to-day basis. The general rule is that during a procurement, agency officials have no obligation, generally, or duty to verify independently the availability of an offeror's proposed key personnel. It's the offeror's responsibility to ensure the accuracy of their proposals, including the continuing availability of their proposed key personnel. But as we noted above, the GAO has this requirement that offerors are obligated to advise the agencies when they know that one or more proposed key personnel are no longer available. Well, what does that mean, when they know? There's a fairly recent case, January 2018, a GAO decision that concluded that if an offeror doesn't have actual knowledge or understanding that one of its proposed key personnel can no longer accept the position, that's not a misrepresentation. They're talking about actual knowledge. But I've got to tell you, the DZSP decision is somewhat unique and based on unusual facts. In that case, the original award was in 2014. We're talking about 2018, 4 years later. There were 4 protests going back and forth. There were 3 sustains by the GAO, so a lot of time had gone by. But the GAO held in that case, contrary to the protesters' allegation, that absent actual knowledge that a proposed key person is no longer available, the offeror has no notification obligation and can remain blissfully ignorant of an individual's changed circumstances until after award, when the awardee seeks to then hire that person. The GAO, I think, really this was a real-world acknowledgement of what can happen during a delayed procurement. As GAO basically said, under circumstances like happened in this DZSP case, you cannot hold that offerors have an ongoing obligation to be in constant contact with proposed personnel to ensure their continuing availability over a long period of time. Personnel can't be expected to be just standing by, not engaging in gainful employment, waiting for the employment opportunity that may not materialize, until some months or years in the future. These people have to be employed, and they have to, do what they got to do to take care of themselves and their families. And GAO recognized that. But again, the circumstances in this DZSP case were somewhat unusual. So even though you can try and rely on that holding that absent actual knowledge, there's no notification requirement, and there's no misrepresentation if that key person becomes unavailable. But certainly, as you will hear later on, you just give it a try. In the CBIS federal decision, it's a GAO decision. It's pretty old. It's a 1992 decision. But this decision sort of shows you that it's really the particular events or circumstances that occur during a procurement that may undermine an offeror's ability to rely on the actual knowledge test applied by DZSP, and it comes into the realm of, did you have a reasonable understanding that the employee, that this proposed person, might not be available? In the CBIS case, The GAO sustained this protest that was alleging that the awardee knew or should have known that its proposed key personnel would not be available for performance. And the facts were, briefly, that after the submission of initial proposals, a proposed key person who was a supervisor, she, quote, withdrew temporarily, and this is the way she worded it, the notice to the person, to the company whose resume she had been used. She said, I'm withdrawing temporarily for work availability because her mother was ill. So shortly after that, in a revised proposal submitted by that offeror, and in response to a specific discussion question concerning that supervisor's qualifications, the awardee didn't mention that that person had temporarily withdrawn from work availability. GAO sustained the protest. Saying that the awardee under these circumstances knew or should have known that this person was not available. Because even after that, responding to that discussion question that I mentioned earlier, the agency requested what back then was called BAFOs 5 months later, and the awardee learned that the individual, by word of mouth, I believe, had gone to England. But they didn't actually speak to her, but they still concluded that she was probably available, so they still included her as a key person in the BAFO. They only sought to replace her after award. The awardee claimed that it just assumed that this person would be available to work on the contract since they hadn't heard otherwise from her, and she didn't formally withdraw her commitment letter that she had signed at the very beginning of the procurement. But GAO said under those circumstances, the assumption was not reasonable that she would be available for work. And then in this case also, there was another person, key person, a project manager, that was proposed by the awardee, and that person withdrew her name at about the time of BAFO submission, and the GAO held that because the awardee had not communicated with that individual during the 8 months that had passed, since she'd signed a letter of intent, the awardee could not reasonably expect that the individual would be available. So what do we learn from this? We learn that you don't necessarily need a formal written withdrawal from an employee, but if you gain information either from that person who maybe withdrew temporarily to take care of her ill mother, or through the grapevine that that person had gone to England, then you can't just stay silent or sit back and assume that that person's going to be available. So it's really, it really depends on the length of time that's passed and the particular facts and circumstances in the procurement as to whether the representation that the person is still available remains valid or not. And I'll turn it over to Scott now.
Thanks, Kim. And there was a question that's been raised that sort of makes a lot of these points. In summary, is, at the end of the day, what happens if the buyer, if the government takes a long time to award the contract and small businesses can't have their personnel just waiting around, and that they do have qualified personnel available, but they're not the same ones in the proposal. And I think, the DZSP decision that Kim talked about, it provides some comfort to contractors that you don't have this continuing obligation to continuously contact your personnel and make sure they're available, and then as soon as they have something happen, then you're all of a sudden on notice of it. But at the same time, that case has been construed very narrowly, and this other case that Kim's discussed shows that if there are some intervening events that you become aware of, that these are very fact-specific situations. And this next case that I'm going to talk about applies that again, but at the Court of Federal Claims. And this was a small business that essentially, as a procurement dragged on for a year and a half, had to make changes to its personnel. And in essence, was burned because of not substituting a person when given any opportunity. Essentially, what this case, the Conley decision, it was issued just a few weeks ago, and it's a case that Kim and I worked on, and it really mixes together the challenges that we've discussed today. In our view, it was a very unfair and unfortunate set of circumstances. Conley was a small business, long-time incumbent contractor, and this was a contract for technical services on Army watercraft around the world. The RFP had, of course, placed significance on the qualifications of the technical personnel that would be performing these repairs, and included requirements for, of course, resumes for their key personnel. The key personnel not only included those engineers performing the work, but as relevant to this case study, it included the individual who essentially coordinated the repairs and the travel schedule for those engineers around the world. And a new 5-year contract was initially awarded to a different contractor, Valkyrie. Conley protested at the GAO. The Army took corrective action, meaning the Army had recognized an error in its evaluations and agreed to reconsider its award. Time passed. The Army again awarded the contract to Valkyrie. Conley protested again. Significantly, however, at this point in time, Conley's incumbent contract had expired. And essentially, the Army chose to abstain from buying these services rather than issue a bridge contract to Conley. And the result there, Conley, again, a small business, couldn't keep around this entire staff doing nothing for months on end, waiting for the government to redo things. And so, in particular, Conley had to lay off the individual who was coordinating the schedules for these engineers, one of its key personnel, referred to as Barber. So Barber had been a key person in Conley's proposal and had to lay him off during the course of the procurement because of the protest delays. Months passed. Conley won its protest at the GAO. In particular, the GAO found that the Army's evaluations were improper, and the GAO directed the Army to go back and correct them. So at that point, it's 4 months after Conley had laid off Barber. The Army had been abstaining from buying these services, but had decided it couldn't go without them any longer and issued a bridge contract with Conley while it redid its evaluations. The intervening difficulty in this situation, though, is that in addition to Barber having been laid off, he went to work for the other contractor in this story, Valkyrie. As it would turn out, Barber had actually provided his resume to 3 contractors, all trying to stay in essentially the same position that he had held for the past 7 years. When this bridge contract resumed performance, Conley tried to hire Barber back, but Barber declined to change again for the purposes of a short-term contract. The bridge contract was only for a few months, and this other 5-year contract was still waiting. Conley interpreted that decision as limited to the bridge contract, that this individual who'd thrown his name in the hat for this job with several different employers and been in this position for 7 years would still come back to Conley if it were awarded the 5-year contract. Meanwhile, in order to address the issues that the GAO had upheld in Conley's protest, the Army opened discussions with offerors, sent out a handful of evaluation notices. As we often see, gave offerors 3 days to respond to the evaluation notices and submit any proposal revisions. With Conley's key personnel, Conley had one change in its key personnel, where one of its program manager had essentially went to law school, and the agency knew it as a result of performance on the bridge contract. But Conley still expected Barber to return if it won, and the Army's evaluation notices hadn't raised his status as an issue. So when Conley resubmitted its resume package to update its program manager, Conley left Barber in as key personnel. Finally, the Army awarded the contract to Conley. All was well and good. Then Conley made a job offer to Barber, asking him to return for this 5-year contract to a position that he'd held for 7 years, a position that he was in Conley's proposal as key personnel on. Barber declined. Barber told his employer, Valkyrie, about the offer. Valkyrie filed a GAO protest, alleging Conley had misrepresented Barber's availability. So Conley attempted, under its newly awarded contract, to offer a substitute key person, in fact, the same person who'd been serving in the position under the bridge contract for several months. The Army didn't respond to that. Instead, the Army took corrective action on Valkyrie's protest, stating that it would reevaluate proposals with its newly found knowledge that Barber was unavailable to Conley, and significantly that proposal revisions would not be permitted. So now Conley was in a situation where it had been competing on this proposal for 1.5 years, and as a result of these delays and the changes in the status of the bridge contract, its key personnel were now outdated, and it had no opportunity to revise its proposal. So Conley protested that corrective action at the Court of Federal Claims, arguing that there's no rational basis for opening the evaluation up again, alternatively that the corrective action should include proposal revisions, that it's only fair to allow Conley to revise its proposal as a result of this post-award development where Barber had rejected the job. And a couple of weeks ago, the court denied Conley's protest. Significantly, the court's decision found that the Army could have rationally found Conley's actions constituted a bait and switch. And this is true even though Conley had expected Barber to return. In doing so, the court applied a relatively low bar to evidence a bait and switch, which conflicts with the test used in DZSP. Essentially, under these facts, the court said it was foreseeable that Barber would not return to Conley. Of course, the court attempted to reconcile all of this by pointing out that if Conley had received definitive assurances from Barber, such as a contingent hire letter, Conley may have been able to show that his actions would not be foreseeable under the bait and switch test. But the trouble that we have with the court's conclusion is that this is a situation where the RFP didn't require contingent hire letters. And so what efforts are contractors supposed to go through in order to assure that this vague foreseeability standard won't be met in their situation? It's certainly a very fact-specific call, a slippery slope, and not too uncommon of a situation. And the Conley case ultimately goes to show that remaining silent when you're faced with possible changes in your key personnel can really result in being burned.
So we've come up with a few takeaways for you based on these sad cases, especially the Conley case, which was a very, very difficult case because of the factual circumstances, which a couple of questions we've received reflect that some of you have experienced this same situation, and it's particularly hard for small businesses who don't have, lots and lots of people on their payroll who are qualified to assume these positions and who they can keep gainfully employed while they're waiting for an award. Going to our takeaways, just repeating what we have said before. Do not propose individuals or use their resumes for key personnel positions without the person's express consent and preferably a signed letter of intent commitment contingent hire for each such individual, even if the RFP doesn't require it. As what Scott just told you from the Conley decision, the judge specifically said, if we had a commitment letter from Barber, if Conley had a commitment letter from Barber, that might have changed the case. Make sure that those resumes or other proposal descriptions of key personnel are current, accurate, and sufficiently detailed to demonstrate that each individual meets the requirements. Scott didn't mention in the Conley case when in the summer after taking corrective action based on GAO sustain, when Conley submitted the substitute proposal manager resume and they just resubmitted the prior resume package, including Conley's. Barber's resume still reflected that he was a current employee of Conley, even though he no longer was. If they changed that to say contingent hire, then probably Valkyrie couldn't have argued that we made an intentional misrepresentation, which it argued very, very vociferously before the Court of Federal Claims. So that's what I mean. You've got to check those resumes and make sure they are absolutely accurate. You can get burned if they're not. If the agency opens discussions and requests revised proposals, make sure to take the opportunity to confirm that your proposed key personnel remain available, especially those contingent hires, and that they're willing to work on the awarded contract. And be sure to document that exchange with that person. So if you make a phone call to John Q. Public, who's working for another company in the meantime, make sure you document that conversation. And if you have that opportunity to submit a revised proposal, obviously submit a substitute for individuals who are no longer available, again, only with that person's consent. But if the agency's indicated either in the solicitation, which we almost always see now, the agency says we intend to make an award without conducting discussions, but we reserve the right to hold discussions. The solicitation says it, or if you know otherwise, that the agency is going to make an award without discussions, and you're told or you learn that the proposed key person is no longer available, you have very limited options under the existing status of the case law. You can either do nothing, stay quiet, request permission to substitute an alternate for that proposed key person if you're awarded the contract, but as these cases that we've discussed demonstrate, you may be in trouble if someone protests that. So you keep your fingers crossed and hope nobody protests. Under appropriate circumstances, such as the individual stating that he or she needs to accept another job due to delays, ask that person to confirm that he or she remains willing to consider accepting the position if and when the contract is awarded. So if you have a contingent hire and that person tells you, gee, I've gotten a really nice job offer somewhere else, and I'm gonna move to Michigan to accept that job. Ask them, well, if we get an award, would you consider coming back? Would you consider accepting the position? And if that person says, yes, I will, ask them to put it in writing if possible, and that may go a long way toward you're being able to counter a material misrepresentation argument by a protester if you are lucky enough to win the award. Alternatively, as a last resort, if you're in the situation where they don't ask for proposal revisions and you know a person's unavailable, you notify the agency and you make your case, urging them to open discussions so that you may provide a substitute and a revised proposal. You make the argument that it's in the best interest of the agency and enhances competition, gives them the potential for a better value, et cetera. You just make the best arguments possible. I'm going to close by mentioning just I don't know if you've ever heard of the National Sabinic Report. It's a monthly publication that is very well known among government contract practitioners, where Professor Ralph Nash and others publish articles or commentary about current and interesting cases and changes in the government procurement law. They've addressed in two separate articles in 2017 and 2018 this very same situation and how terribly unfair it is, the state of the law in circumstances where key personnel become unavailable during a procurement. And in fact, one of the articles actually mentioned a proposed FAR change, which I don't know whether it's going to ever happen, but that requires agencies under those circumstances to open discussions and allow for, limited revised proposals to allow for companies to substitute qualified personnel. They're an interesting reading, and we can certainly provide you with cites to those two articles. But again, they're both focusing on cases at the GAO and at the Court of Federal Claims that have very unhappy results, such as the result that we have described in the Conley and Associates decision. That is the conclusion of our presentation. I want to thank you for participating in our webinar, and we would really appreciate it if you would complete and submit the survey located in the widget at the bottom of your screen. Thank you very much, and have a good afternoon.